So we would like to continue our health care and human rights discussion. So we are going to look at this thematic area in our today's class, AIDS policies and practices. We will be exploring the human rights, public health, ethics, and global governance dimensions of the HIV/AIDS pandemic. And we will be focusing on a very interesting publication by the well-respected Lawrence Gostin on the HIV/AIDS pandemic, complacency, injustice, and unfulfilled expectations. So we use that as our key text of discussion, and our own Ghana AIDS Commissioner 2016 Act 936, which repealed the 2002 So in the course of this lecture, we try and explore the key differences which exist between the new version 2016 legislation and the 2002 one. So it was useful for us to have brainstorm ahead of this discussion. As I said, the issues are many. And so I'd just like you to have these questions at the back of your mind as we proceed in this lecture. So first, if the state claims that restricting certain individual rights is necessary to control HIV/AIDS, what criteria should we require the state to satisfy before we accept that claim? And again, who should determine whether those criteria have been met? And at what point do such restrictions cease to be justified and become counterproductive? The second set of issues we need to have at the back of our mind as we progress is this. When stigma attaches to HIV/AIDS, is it accurate to treat it as merely a social or cultural prejudice? Or can stigma be produced, reinforced, or legitimized by law itself? You all know stigmatization associated with HIV. So it's just a matter of social or cultural prejudice, or our legal arrangements, our laws as they are, also fuel, contribute, exacerbate this stigmatization associated with HIV/AIDS. Now, related to that, if law has played a role in creating a stigma, does it have a corresponding duty to dismantle it, to reverse it, to reduce the stigmatization? And how far should that duty extend? And then the final or the third set of questions to ponder are that where effective HIV treatment exists, maybe probably such as antiretroviral drugs and other treatment, but remains inaccessible to millions, should this be understood primarily as a failure of national governments, the national institutions, market forces, or global ethics? And in legal terms, how should responsibility for addressing HIV/AIDS be allocated beyond the boundaries of the nation state? So these are the pertinent issues which we need to keep at the fore of our mind as we explore this topic further. So to start with, there's no doubt that HIV/AIDS is a legal and a policy problem. And HIV as a pandemic goes back to the early 80s. And that is why it is said that it is not just a crisis for biomedicine. It's something which has got triangular dimensions: legal, ethical, and governance. And since HIV assumed the scale of what we call pandemic in the 80s, it has tested the capacity of legal systems to strike a balance between public health imperatives with human rights protection, particularly when it comes to vulnerable and marginalized population. Of course, like all public health issues, they present their own challenges in how you navigate so as not to unduly undermine human rights and freedoms of people affected by the particular public health issue that you are dealing with. So in Lawrence Gostin's article, he makes the point that the HIV is a moment of unfulfilled expectations. And in his view, despite scientific progress, responses have been weakened by complacency, inequality, and persistent human rights violations. Even from our pre-class discussion, the Socratic engagement that we did before starting this lecture, from the responses that you gave, they reinforce the view which Gostin is making, that there has been significant complacency as far as the effort to contain HIV is concerned. And if you are to do a check in our jurisdiction, for example, you can legitimately say that for more than a decade, or nearly a decade or 2 decades, the campaign to create public awareness, consciousness with respect to the reality, the danger, the menace of HIV/AIDS has significantly gone down. So much so that it has been normalized. It's become like a normal thing. And people do no longer feel it, or they do not see it as a threat and something to be very careful. So therefore, if we wanted a phenomenon which provides a critical lens for examining how law mediates state power on the one hand, individual autonomy and collective welfare on the other, is probably the way HIV/AIDS has been dealt with. Now, if you look at various jurisdictions, notice that policies around HIV/AIDS have actually relied initially on coercive public health measures. That is, including things like mandatory testing. You must go for HIV testing, whether you like it or not. And even some countries have made it part of their immigration policy. I remember in 2003, when I was going for my LLM in UK, for the first time, whether I like it or not, I had to go and do HIV/AIDS test. Now, the coercive public health measure with respect to HIV policy also include quarantine proposals. Some will say that, well, should we even quarantine people who are HIV? Should we criminalize transmission? So that if positive, and you go and have unprotected or what they call the raw sexual intercourse with another person, should your behavior be criminalized, knowing that you are positively infected and you could pass it on to the other uninfected person? And again, immigration exclusion. Some countries, if you are HIV positive and you want to come in, they will not allow you to come in because they will say that you have not even succeeded in trying to contain our people who are HIV positive. So why should we allow you to come and add to the problem that we have not been able to deal with? Now, these approaches to HIV/AIDS policies, they just drew upon traditional infectious disease control models, and no wonder they have proved ineffective and to a large extent counterproductive. And what we have seen as an upshot is that it has effectively driven the epidemic, the HIV epidemic, or if you even call it the pandemic, underground. It's been swept underground in the sense that just like our recent coronavirus, it has been driven underground. We are thinking that, well, the virus is gone, so nobody is taking the requisite precautionary measures so as to avoid being infected. In the same vein, HIV/AIDS, it does not receive the needed public discourse so as to remind people with the requisite degree of the alarm that, yes, the dangerous disease is still there. And again, because it's gone underground, the related effect is increasing stigmatization. If you have active public education, you have a way to control the stigmatization, and people will no longer see it as a stigma. But once it goes down and somebody is infected and it comes out, the person becomes like a subject of a rumor or public gossip. So that is the point. And that is why Lawrence Gostin, in his work, puts up the argument that HIV/AIDS caused a paradigm shift from authoritarian public health to right-based public health. And I would like you to pay attention to that paradigm shift we're talking about. The fact that we have authoritarian public health approach on the one hand, then we have the rights-based public health approach on the other hand. And in his view, if you look at how HIV has been confronting our nation states, you'll notice that, and looking at the UN also guidelines, nation states have been forced to abandon the traditional coercive public health or authoritarian public health model to human rights or rights-based public health model. In that, the HIV policies are calibrated to advance human dignity, equality and non-discrimination, participation and accountability, and also evidence-based interventions. And if you look at that paradigm shift, it's very much in alignment with international human rights law, particularly so the ICCPR that we have cited before, International Covenant on Civil and Political Rights, and then ICESCR, International Covenant on Economic, Social, and Cultural Rights. Now, the UN has provided its guidelines, which supposed to guide states in formulating HIV/AIDS policies. And the first of such major guidelines was the one issued in 2002. Now, these guidelines are not treaties, as their name suggests. That notwithstanding, they carry significant, please note your questions and issues down. They carry significant interpretive and persuasive authority when you are trying to articulate binding human rights norms and how they apply with respect to HIV/AIDS. And they reflect the Belgian consensus that effective HIV/AIDS policy is impossible without human rights protection. That is to say that based upon various practices which have been deployed by states, since the HIV menace assumed the scale of a pandemic, as it were, observing the various efforts by states, the failures and the limited successes, there is now understanding commonly held that if you want your HIV policy to succeed, you must follow the human rights protection model. It should be rights-based approach rather than just the coercive public health measure model. That is the point being made. So if you look at the UN guidelines, particularly revised guideline 6, it addresses criminalization aspect of HIV/AIDS policies, and it urges states to avoid overly broad criminal laws relating to HIV exposure or transmission, and also ensure that, I want you to have this at the back of your mind, because at the end of this general discussion, we are going to look at the Ghana AIDS Commission Act, and we need to find out to what extent our own domestic legal policy on HIV reflects the emerging consensus or the best practices as reflected in the UN and other international guidelines. And the revised guideline says also states are to ensure that criminal liability is limited to intentional transmission. Intentional transmission, that is to say that a person is aware of his status and he wants to have sexual intercourse, and he doesn't, use any precaution, have unprotected sexual intercourse. So that is intentional transmission. Just like some years ago, I think in Asante Bekwai, a gentleman was said to have come from abroad, a Ghanaian, and was just moving from hotel to hotel, sleeping with women without protection when he himself was HIV positive. So that is the kind of thing we are talking about, intentional transmission. And it also urges states to repeal laws that criminalizes, laws that criminalize HIV status. If someone is, HIV positive, that should not be framed as a crime. And laws that criminalize same-sex conduct. That is, if two males want to have sexual intercourse, females want to have sexual intercourse, that it should not be criminalized. But that is a controversial area. And also laws that criminalize sex work, drug use, where such laws undermine public health goals. Sex work, for example, if you come to our country, Ghana, for example, where I live in Cantonment, if we just drive down the Togo embassy area every night, from 5 going, you see sex workers paraded around. But here is the case, they are not regulated by law. And once they are not regulated, you cannot get them to adopt practices which are safe. So that is the difficulty. And that is why the guideline was saying that states should repeal laws that criminalize sex work. And if you read the guideline, it explicitly recognizes that criminalization of HIV status or those activities which are considered to be predisposing people to HIV increases stigma or stigmatization and deters testing and undermines trust also in health systems. Certainly, if it is criminal, then why will I go to be tested? So that is the concern. And if you take countries where their domestic regimes continue to criminalize non-disclosure or perceived risk, that is to say that if you are HIV/AIDS and you don't disclose it, then that is a problem. Now, some countries actually have the practice of, if you're HIV/AIDS, it doesn't matter that you do not have intent or you didn't, actually, seek to transmit it. You have to disclose it. So that is a problem. And of course, that is actually frowned upon by the letter and spirit of this UN guideline. We also have the big problem of discrimination, stigma or stigmatization, and then structural injustice. HIV/AIDS is, for example, seen as a disease of inequality. And Lawrence Gostin will make the point that HIV/AIDS does not affect population equally. It disproportionately affects women and girls. And girls are disadvantaged, particularly when it comes to even consensual sex and non-consensual sex. If you are talking about rape, yes, in those countries where homosexuality is recognized, a man can be raped through the anus. That is fine. But that is on the relatively reduced scale as to heterosexual rape. And if a woman is raped, she certainly stands the risk of being affected, no doubt. Then it also disproportionately affects men who have sex with men. We even used to hold the view that HIV started with the gay, that is men sleeping with men. HIV/AIDS also disproportionately affects sex workers, what we call commercial sex workers. And then people who inject drugs as well as the migrants and prisoners. Particularly prisoners. If you've done a bit of work with the prisoners, you notice that when they are there, whether you like it or not, sexual intercourse is part of the biological processes. That not until you have maybe consciously trained yourself, the urge will come. And someone who is going to be removed from his wife or sexual partner for the period of confinement, there will be that tendency to either sleep with other men or they are forced to sleep, and the HIV get infecting them and spreading within that community. So these groups are marginalized by law. They are marginalized by law, and their vulnerability is compounded through criminal law, as you have seen. Most of the things, we have a criminalization. Immigration law, give you example, and even family law, as well as the labor law. Family law, for example, when it comes to marriage, particularly some of the churches, that you are supposed to go for compulsory HIV tests before you be given clearance to marry in the church, as it were. It's not the test per se which is problematic, but what happens after the person has gone through the test? Assuming the person is positive and he or she, they are not going to be allowed to marry. How does that information is protected so that they don't get stigmatized? And labor law too, where a person is required to disclose or not to disclose his HIV status, depending upon how the law is actually framed. They may all worsen the problem of HIV/AIDS pandemic. And in that respect, Lawrence Gostin will say that the HIV/AIDS pandemic has brought about what we call structural injustice, in the sense that social arrangements systematically disadvantage certain populations. So just like the people we'll be talking about, women and girls, men who have sex with men, sex workers, people who inject drugs, migrants and prisoners. The situation of these subpopulations are largely as a result of social arrangements. Now, what are the legal duties of states under international human rights with respect to AIDS? Well, states have two sets of obligation. First, they have negative obligation to refrain from discrimination and coercion. So it's negative in the sense that it does not expect the state to consciously do anything, but to avoid encouraging practices and behaviors that bring about HIV/AIDS related discrimination or coercion, as it were. States also have positive obligations to ensure access to prevention, treatment, care, and support. So these obligations which the state have actually encapsulate access to antiretroviral therapy, ART, which we are told HIV patients are supposed to be on for almost all their lives, as it were, so as to avoid the their immunity breaking down completely, and they becoming susceptible to all manner of diseases, which can accelerate their death. State duties also include ensuring that there's access to confidential testing and counseling. There should be access to confidential testing, and people should be encouraged to freely go and be tested and know their status. And people should be advised that it is far better to know your status than to live in ignorance about your status. But once you know your status, you know how to adjust your lifestyle, how to seek antiretroviral therapy or any interventions that may be there. There should also be access to, the state should also ensure access to harm reduction services. Harm reduction services. Sexual and reproductive health services. So therefore, where a state fails to ensure access to antiretroviral therapy, confidential testing and counseling, harm reduction services, and also sexual and reproductive health services, that may constitute a violation of the right to health protected under Article 12 of the International Covenant on Economic, Social, and Cultural Rights, as we have been discussing in our previous lectures. Yes, Adeline.
She said the state is to ensure access to antiretroviral. Last year, okay, so the late part of 2024 and then the early part of 2025, there were news on TV3 and other outlets about how they didn't have stock and the antiretroviral drugs of any or groups or any think tank. So when it comes to such situations, how do we handle such if they are supposed to make even out? There are some places that because people do not have enough money to travel to get their medications, they default as well. Thank you.
Right, thank you. Yeah, so where you have allegations of expired drugs, for example, this is where we expect our journalists. If we take our journalists to large extent, they are too much interested and obsessed with political news rather than other non-political or non-sensational news. So we need to have our journalists, diversifying their interests. And where investigative journalism can actively follow some of these and mount the necessary pressure so that justice will be done in situations like this. Okay, we also have Robert Stenbrooks, who did a work reflecting on the AIDS epidemic in global context. And in his assessment, he underlined the central paradox or the key problematic in this area, that scientific advances transform HIV into a manageable chronic condition in high-income countries, so like the developed countries, because of scientific progress, trying to get antiretroviral and other immune enhancing intervention. HIV is not a death warrant. Yet, millions continue to die in low and middle income countries due to lack of access to treatment. So therefore, if you have, let's say that 10,000 individuals infected in developed country and another 10,000 infected in low and middle income countries, you are likely to have the 10,000 HIV patients in the developed countries actually living probably their normal lifespan or substantial part of their life span, but same cannot be said of those in the low and the middle income countries. I mean, that is a reality. And for that matter, Steinbrook points out, he use the data. If you look at the write-up itself, that global disparities in access to antiretroviral therapy. There's also the problem of the intellectual property regimes. People who get various treatment for HIV, they need to have the intellectual property protected, despite the fact that under some concession arrangement, in some cases, generic versions are permitted to be produced. And those in India are actually good at that. Almost every medicine, they have its generic version as it will. And generic versions is as good as the original one because we are told it's the same active ingredient, which is in there. It's just a branding and few other things which actually change. And again, he also points out the dependence of many countries on donor funding. We take United States, USAID, for example. USAID providing support, let's say, for HIV/AIDS policies and programs. And just recently, we have the United States, when President Trump came to power, trying to scrap support, which is provided under the auspices of the USAID. So if your HIV program, for example, depend upon that, you are going to have a big problem. Another article we have referred to the David Starcher's work, Ethics of HIV/AIDS Research in Developing Countries, and he makes a similar point as the other writers have made, particularly the ethical complexities of conducting biomedical research in developing countries, where we have high HIV prevalence. And the ethical concerns here include exploitation of vulnerable populations. A lot of trials, investigations are made in developing countries, and just recently that the necessary awareness is being created. And then they are conducting trials, they're carrying out the research. We don't even know, and people are just enrolled, thinking that they are doing them a favor, not knowing that we are rather trying to use them as a guinea pig, as it were, to find out how they react to certain drugs and certain procedures. So those are some of the problem. And again, the use of a placebo controlled trials, where effective treatment exists elsewhere. These are all ethical problems which are encountered as far as developing countries are concerned. And for that matter, David Satcher insists that ethical research must satisfy scientific validity, respect for persons, a fair distribution of benefits, and then post-trial access to successful interventions. Just mind you, or just know that they will come to a developing country to conduct a test of maybe certain drugs or certain procedures. And then they will go and finalize and validate it. But even if it's successful, those who were used as the target population for the trial or the testing may not even benefit from the final product. So that is the agony and the irony of the whole thing. Let's take, for example, when it comes to malaria treatment, if you go to the developed countries, they have malaria treatment and they have some which are in the form of, I don't know whether the doctors call it prophylaxis or something like that, so that when you are traveling to malaria, mosquito, endemic region, you will take certain shots. Yes, David Tete.
Yes, my lord. Please. So in those cases where they come in developing countries like Ghana, and you mentioned that sometimes developing countries do not benefit from the product that will be developed. Do they contact our government authorities before they do the trials? And so why don't they negotiate that at the end they put out the product that will coming back to their country? Or do they not have that kind of right or not kind of chances to negotiate whenever they coming to do the trials?
All right, thank you. Yeah, so we have like our Public Health Act, for example, of 2012, which has come to streamline clinical trials and some of these biomedical research. But again, just like Ghana Standards Authority, Food and Drugs Authority, we have good laws, good frameworks, but the human beings who are mining the operationalization of these legal frameworks and structures, they will need to be more, patriotic. That I won't say much, but what I've said, you can take a lot from that.
Okay.
Yeah. So what we have seen, or the point David Satcher is trying to make, coincidentally, we got the David Tete who was interested in commenting on our discussion of David Satcher's discussion. They actually, strike at the. You want to say something? Who is trying to speak? Is somebody trying to speak? Oh.
My lord, I think it's one of our colleagues whose mic may have turned on. I don't think it speak directly.
Wisdom, please. Mute. Wisdom, mute. Who is the person? Mute the person.
She's Patricia.
Okay, let me see.
Patrick. Okay.
So the ethical debates surrounding HIV research have influenced development of various international research ethics guidelines, national regulatory frameworks, including the public health that I mentioned, as well as the Ghana AIDS Commission, which we'll be looking at. And also some more judicial scrutiny of clinical trials. But Ghana, you don't have litigation in these areas. Maybe some of you going through this program may develop the interest to be pursuing some of these measures. Now, despite the progress which have been made with respect to building the requisite legal and ethical framework to contain some of the challenges associated with HIV/AIDS, there are still significant challenges. We have persistent criminalization of HIV exposure in some jurisdictions. We have gender-based violence and HIV risk. We've talked about rapes and so on. Inadequate protection of privacy and confidentiality. Now here, in some jurisdictions, we have the law there, but the human beings who are mining the system, they have not disciplined themselves. I know, for example, in some hospitals, you go there, a person is tested HIV positive or any STI, and the information is all over. So here, it's not the failure of the law. It's the failure of the human beings who are in charge of the systems as it were. And there's also the challenge of unequal access to new prevention technologies. Understand the various prevention technologies which are out there. Of course, we have even the prevention of mother-to-child transmission, where HIV mothers can give birth to children who are not HIV. That procedure or system is there, but we would like to know from practitioners on the field as to whether it is a procedure which is commonly available, especially in our country, Ghana, so that wherever you are, if you're HIV pregnant woman, can you expect that you will benefit from the prevention of the mother-to-child transmission? Is it commonly available?
So you mean the
PMC commonly available?
Yes.
Everywhere you go in the country?
Yes, in a general hospital. Yes.
Okay, all right, that's good. That's good.
Saying it depends.
No, even at the cheap compounds, I know as low as the cheap compounds, they do PMCCT.
Okay.
Because we're supposed to have focus antenatal, and the midwives are being trained on how to administer the medication. So if you run your antenatal clinic at the CHIPS compound and you have a positive, it makes it more easier. You liaise with the HIV coordinator and you are being given the medications to administer to your clients. When it is time for delivery, because you want safer delivery, if you feel that at that level, you are not too comfortable to deliver the mother, you refer the mother. Or during delivery, coordinator, if the CHIPS compound doesn't have medications, they give you the one they are supposed to give to the baby, the serum, and you administer. So even at the CHIPS compounds, there is HIV medication.
All right.
For pregnant women.
Right, that's good. That's
I support the private hospitals who want to do their own thing. But like I said, because of network of practice, now as a sub-district or district, you are supposed to engage all the private maternity homes within your catchment area to make sure that you make those medications available for them for PMTCT services.
All right, thank you.
Okay, if it's like, because I know even as middle of last year, some facilities, even health centers, have to refer the people to the district for them to go through the counseling and have those medication administered. That's why I was questioning
the protocol refer the pregnant woman. You need to make sure that as a facility you have the services, because the medications are free. It is because of the fear of expiration and all that. So at some levels, they don't want to stock their drug because we don't have too many positive clients at that CHIPS compound. So if you keep them, it will expire. But you need to be actively involved in the process, making sure that if you run your antenatal, you test the mother on first visit. Make sure if you test and it's positive, within 1 week, you should be able to get medications from the next facility, next available facility, because the medications are free. So if at the end of the day you have to refer the mother to be roaming around, then there is something wrong with communication or chain of command. I don't know.
Exactly, because right now what people are interested, either they are under it comes to the paper, we're skipping data, you see it nicely, we have APC. But when you go on the field and experience what is actually happening, then you get to really understand, because I do which that we get to do from the teaching hospital here to
you have to,
and I get to read these things there.
Right. So all right, thank you very much. So we have to continue. So the lessons we draw from the foregoing discussion is that HIV/AIDS has actually reshaped public health law, in the sense that we have come to notice that coercion undermines health outcomes. It's not advisable to use criminalisation, to use threat of force to solve certain public health problems like HIV/AIDS. Again, human rights protection enhances public health effectiveness. If you use a right-based approach, it's more reliable and more effective than using the coercive public health measures model. And in that respect, law is a determinant of health, in the sense that law can fuel the problem. At the same time, it can also be a catalyst in its solution. HIV, if, for example, you legalize, let's say, same-sex work, and say that, not same-sex, commercial sex work, and say that those who are going to be sex workers should be licensed. You can now put in place measures that you need to go for periodic testing and so on. You can regulate the person that you are helping to address the problem, and so on and so forth. So if you want a very good case study of right-based public health governance in public health issues, I think the HIV problem present one good example. And to large extent, recent epidemics like Ebola, COVID-19, the HN5, and so on, all benefited somehow from the approach which states adopted to deal with the HIV pandemic. And that is the argument that Lauren Austin make. So he reminds us that the true measure of success is not the innovations being made in the biomedical sciences, but it should rather be whether law and policy promote justice, dignity, and solidarity in the face of the disease. Can make the advancement, as somebody pointed out, if you go like the developed or the richer segment of society, they can benefit from certain advances which have been made to address the problem. But those who are relatively poor cannot. So you come back to issues of law, justice, and then solidarity, rather than just only the scientific progress being made. So we would like to look at the situation in Ghana. How is HIV is a governance and a human rights issue. So, as Gostin reminded us that HIV is not just a biomedical issue or just a problem we have with respect to epidemiology, but it is an issue, a composite issue, a cross-cutting issue, triangulating public health governance, human rights protection, social justice, and national development. And that is why, as we come to look at the Ghana AIDS Commission at the original one, 2002, and then the 2016 one, you will appreciate that HIV/AIDS was seen as a developmental national issue. And that is why the presidency and the very higher echelons of society leadership even had to come into it. So we, just after looking at the relevant aspects of Act 938, that is the Ghana AIDS Commission for 2016, we will try and do a comparison of this and then the repealed 2002 version. But by and large, the Act 938, which is the 2016 Act, is a very comprehensive legislative response to the problem of the HIV/AIDS. And if you look at the long title of the legislation, which is the statement of purpose of that legislation, it says that the Act consolidates earlier policy approaches and explicitly integrates human rights norms, institutional coordination, and accountability mechanisms into national HIV governance. So the Ghana AIDS Commission is set up, and its mandate is to formulate policy on the HIV and AIDS epidemic and to direct and coordinate activities in response to the HIV and AIDS. So all the discussion that we'll be having earlier on with respect to how the HIV problem can be addressed and improved, I think that the body that we should direct our calls and appeals to is the Ghana AIDS Commission, and that is their mandate, as Section 2 of Act 938 makes clear. And it is reassuring that the Ghana AIDS Commission is given a very overarching mandate. So from institutional design perspective, what our Ghana AIDS Commission is mandated to do very much reflects what was in Lawrence Gostin was telling us, that if you have a fragmented responses to HIV or to AIDS, it will weaken the effectiveness. And that is why centralized coordination with multisectoral participation is essential for public health. And if you look at the AIDS Commission, the composition, to a large extent, we see that multisectoral governance. So how is the multisectoral governance model reflected in the composition of the Ghana AIDS Commission? So the governing board, we have senior political leadership. The president is supposed to be the chairperson. We have key ministers like health, gender, local government, public health institutions, civil society, and networks for persons living with HIV, religious bodies, labor, employers, and traditional authority. If you look at section 4 of the Act 938, all these stakeholders are given a seat on the board of Ghana AIDS Commission. And what that means is that the commission, if you examine the composition, the commission or the law is not letting us approach HIV as just a health sector issue, but it is a multi-sectoral, and that is why it intersects, labor law. We have in the labor represented employers, labor, with education, family life, religion, culture, and governance. So we have what we call the all hands on deck approach, as it were. Again, if you look at our Ghana AIDS Commission Act 2016, you come to appreciate that the law clearly affirms that person living with or affected by HIV, quote, shall enjoy the fundamental human rights and freedoms enshrined in the Constitution. So if you look at section 28 of the legislation, it makes that point. And clearly, that puts the HIV legislative policy framework on the constitutional pedestal. And it dovetails perfectly into Article 12 of the 1992 Constitution, which enjoins all branches of government and other sectors of societies to ensure that the human rights enshrined in the Chapter 5 of the Constitution are enjoyed by all persons. And all persons here include HIV affected or infected persons. And if you look at scholars like Lawrence Gostin, he will make the point that where HIV protection have been constitutionalized, that is an evidence of a matured HIV governance system. So to the extent that section 28 of the Ghana AIDS Commission says that all HIV affected persons are supposed to enjoy human rights protected, that actually indicates that we have constitutionalized the HIV protection. Again, non-discrimination is a core legal principle of our HIV law. So if you look at section 28 of Act 938 again, directly and indirectly, it prohibits discrimination on basis of actual or perceived HIV status and makes the provision that HIV persons are entitled to private right of action for damages if you have been discriminated against. You can sue for damages. You're entitled to have your proceedings in camera to protect privacy. So, for example, if you have sued that someone has actually discriminated against you because you're HIV positive, and the matter should go to court, the court will have to hold your proceedings in camera, that is, not in open court, so that your privacy is safeguarded. And here, the law is trying to protect persons infected against stigmatization and also discrimination. And this is consistent with the guidelines provided by the UN HIV AIDS guidelines. Now, what about the right to health and access to care? At Section 29 of Act 938, it recognizes the right of person living with HIV to a reasonable standard of care. So all the things that we'll be discussing are applicable mutatis mutandis. And again, when it comes to medical research and treatment, Section 29, particularly subsection 2 and 3, talks about the fact that informed consent should be obtained from persons living with HIV before you can subject them to any medical treatment or research, as the case may be. And of course, this also resonates strongly with what David Stachas told us in his article not long ago, when he discussed the ethical analysis of research involving countries, and where he warns us against exploiting vulnerable populations and pointed out the need for robust informed consent and post-trial benefit sharing. After the trial, the final product should also be shared with those who participated in the trial. Now, in terms of privacy, confidentiality, and data protection, Section 30 of the AIDS Commission Act establishes a strong right to privacy and confidentiality concerning HIV status and prohibits disclosure without written consent, subject to very limited narrowly defined exceptions, such as clinical necessity. So clinical necessity here will mean that you are going through treatment. Of course, your status should be known before you can be given the needed and beneficial treatment. If your status is not known, you may not be given the right treatment. Again, when it comes to epidemiological research with anonymity, where they are doing a research on the epidemiology in an anonymized fashion, in that case, your status can be known so long as there's not going to be particularity or identification will link to you. And the court order, Section 30, subsection 3, also provides that in appropriate situation, the court may order that a status should be disclosed as it were. So, for example, if there's a litigation concerning permission that you have stated in the maybe in the public that somebody is an HIV positive, and then the person has sued you, to enable the court to adjudicate, at some point, it may be necessary for your medical records regarding your HIV status to be disclosed. Otherwise, the case cannot be adjudicated. So Section 30, subsection 4, provides that the person living with HIV shall not be compelled to disclose their status, except as provided by law. And this is particularly significant in the light of the discussion we've been witnessing with respect to international debates around HIV criminalization, mandated disclosure, particularly as seen in revised guidelines 6. Now, when it comes to employment and labor protection, with respect to HIV infected person, Section 32 and 33 of Act 938 prohibits HIV testing as a condition for employment. It prohibits termination based solely on HIV status. And it also prohibits work discrimination. While at the same time, it requires reasonable accommodation for workers with HIV-related illness. So, within the context of our Act 938, the Ghanaian Commission, particularly Section 32 and 33, you cannot insist that a prospective employee should undergo HIV tests before you give him or her employment. In the same vein, if the person is an employee and subsequently he becomes HIV positive, you cannot use that as the sole basis, a sole ground for termination of his employment. You can also not discriminate in the workplace. You can't say that, okay, our staff who are HIV positive, this is where you'll be working. Or during lunch time, this is where you sit. No, it doesn't work like that. Then when it comes to education, political participation movement too, the Ghana Commission Act guarantees equal access to education. So the fact that you're HIV positive does not mean that you shouldn't go to school or you should be excluded from political participation. In fact, Section 34 guarantees all your political rights, including standing for office. You cannot say that somebody is HIV positive, so you cannot be voted as a president of Ghana, as a speaker of parliament, or as a chief justice, or as a member of parliament. No. Again, Section 35 protects freedom of movement and grants protection against quarantine or deportation based solely on HIV status. So unlike some countries where HIV status may become a ground for you not being allowed to enter the country, in Ghana, you cannot be denied entry just because you're HIV positive, as it were. Again, when it comes to sexual and reproductive, Section 36 of our law affirms that persons living with HIV are entitled to sexual and reproductive health rights. They have the right to marry and found a family. And then you cannot have their marriage opposed solely on basis of HIV status. And that is why in those churches, I'm not mentioning them, but you know some of the churches, where they say that you have to go for compulsory testing. And then later on, when you are found to be positive, and you say that you cannot marry, that may be problematic and is also against the law. It's up to the other party if he or she wants to run the risk, or they can be having protected their sex throughout their life if that can be safeguarded. So here, you notice that issues like gender inequality, reproductive autonomy, and social exclusion, which are said to be the drivers of HIV vulnerability, as the scholars like Lawrence Gostin and others point out, have to large extent been addressed by our Ghana Commission's Act. There are robust enforcement mechanisms. So the rights which have been stated in Section 28 to 37 can be enforced using Article 33 of the Constitution. look at 33 of the 1992 Constitution that the rights enshrined in Chapter 5 are not limited to only the rights therein, but all rights which are considered inherent in a democracy. And the rights that we're talking about here are definitely considered as being inherent in democracy and also enjoyed in some other jurisdictions. So you can use a procedure for enforcement of the human rights and Article 33 to enforce these rights as well. So let us take note of that. And here, you notice that there is an attempt to expand access to justice and also recognize the role of public interest litigation in HIV governance. Now, criminal law has not been taken out completely. There are criminal sanctions. For example, if you try to discriminate against HIV person, that is criminal. In the same vein, that criminalizes unlawful disclosure. It also criminalizes denial of barrier. You can't say that maybe somebody is HIV positive, so the person should not be buried like any other person when the person dies. It also criminalizes denial of employment, education, insurance, or other movement rights because of HIV status. So look at Section 39 of that legislation. So, mind you, the criminalization here is not to do with HIV status or transmission, as condemned earlier on by the scholars. So that's what the criminal law is being used in this legislation. It's rather being used to protect against right violation. And this is consistent with the UN position that criminal law should protect and should not stigmatize, as it were. So if we are to situate our Ghana Commissions Act or Ghana's legislation in the global context, notice that our law closely aligns with the UN HIV/AIDS human rights guidelines and all the good points or the best practices canvassed by Lawrence Gostin with respect to the rights-based public health model, also reflected in our own legislation, as it were. And again, the ethical concerns raised by the researcher with respect to research and consent have also been addressed. And to some extent, the global inequities, which Steinbrook pointed out, have also been addressed. But we still have a problem with the, what we call the implementation enforcement. So we have a good law, but how do we get it implemented? How do we get it enforced? And also the issue of public awareness of rights. As we've noted earlier on today, before the lecture from our discussion, public education has gone down. And once public education has gone down, people will not be aware of their rights. And that in itself will not help in their coming out to be tested. There's also a challenge with respect to balancing cultural norms with legal protection. And also, how do you ensure sustainable financing of HIV responses? That is a problem. Antiretroviral therapies, prevention of mother-to-child transmission, all these require money. And how do you finance it on a sustainable basis? Now, this, our Act 9.3, that is the Ghana AIDS Commission Act, is very important because if you look at our African state, we can say that our legislation is one of the comprehensive rights-based HIV status in Africa, in the sense that it transforms HIV/AIDS from a domain of fear and moralization into one of law, dignity, accountability, and public health effectiveness. So it's no longer a question of whether you are a bad person or you are morally bankrupt. That is why you've contracted HIV. That is not the perspective of our law, and that is very important. And that is why scholars, like Gostin, have made the point that the ultimate success of HIV policy lies not only in biomedical outcomes, but in whether the law affirms the humanity of those most affected. So we have a good law, but the most important thing is the faithful implementation and also enforcement. Now, just before we go, I told you that we used to have the earlier version of this law, that is a 2002 at 613, before switching to the 2016 version, Act 938. I want us to just do a brief comparison of the two. But just for the record, the 2016 version, that is Act 938, has repealed. Repeal means that it has abolished or cancelled the old legislation of 2002, that is Act 613. But it is worth looking at maybe some differences between the old and the new, so that we appreciate the progress the law has made in this respect. So in terms of policy coordination, we have moved to right-based legislation. So if you look at the old legislation, as 613/2002, you can have the two legislation there, but if I share the 2002 with you, know that it's just for academic purpose because it's repealed, so don't be citing it. Now the 2002, that is 613, was primarily an institutional and policy coordination statute. It focused on formulating national HIV/AIDS policy and coordinating programs, but there was no explicit codification of rights of persons with HIV. As you will notice, from section 27, 28, and so on of the 2016 legislation, we have a very compendious articulation of rights of persons living with HIV. That was missing in the 2002 version. And there, human rights protection was implicit and indirect. You had to infer rather than seeing it explicitly enshrined therein. But if you look at the current or the 2016 legislation, that is Act 938, it explicitly transformed HIV/AIDS governance into right-based legal regime. Not just a policy formulation, but a right-based legal regime. And it dedicates entire part, that is section 28 to section 37 thereof, to human rights of persons living with HIV or AIDS. This was conspicuously absent in the old legislation, that is a 2002 edition. So that is significant. And that part recognizes enforceable rights, as we'll be discussing, including non-discrimination, right to health, privacy and confidentiality, employment, education, insurance, political participation, sexual and political health rights. And this matters because Act 938 has moved HIV/AIDS from policy space into constitutional and justiciable legal space. And that is very important conceptual progress which have been made in that respect. Now let's look at another thematic area for purposes of comparing the 2002 and the 2016 edition. Now, in terms of justiciability and for enforcement of HIV-related rights, the Access 1.3, that is the 2002 legislation, which has been repealed, contain no enforcement mechanism for HIV-related rights. There's no provision which allow individuals or NGOs to sue for discrimination or right violation. And court had no statutory guidance on HIV-specific claims. But if you look at the 2016 legislation, that's Act 938, it makes HIV-related rights directly enforceable under Article 33 of the 1992 Constitution. And you can see this from Section 38 of the Act 938, which allows individuals, public agencies, NGOs, to institute proceedings on behalf of affected persons. And this is significant in the sense that it shifts HIV law from administrative governance to constitutional litigation. And that enables strategic and public interest actions. And that is why it's important. The third thematic area for comparison of the 2002 and the 2016 legislation is the introduction of criminal liability for rights violations. Now, under Access 1.3, no offenses or penalties relating to discrimination, disclosure, or denial of access was actually created. And Access 1.3 relied entirely on moral persuasion and administrative coordination. But if you look at the new legislation, that's the 2016 edition, Act 938, it criminalizes HIV-based discrimination, unlawful disclosure of HIV status, denial of barrier, discrimination in employment and education, insurance, and political rights, as we have seen, and also prescribed fines and custodial sentences. So we see Section 39 of Act 938. And this matters because criminal law is redirected away from punishing HIV status and towards punishing right violations. And this aligns with the UN HIV, AIDS, and human rights guidelines. The fourth thematic area of comparison between Access 1.3 and Act 938 is the right to health and informed consent. And this is an entirely, or is a novel addition to the law. Access 1.3 was completely silent on the right to health, consent to treatment or research and medical ethics. And there was no linkage to patient autonomy. But in the 2016 edition, that is Act 938, it explicitly recognizes the right to a reasonable standard of health. You can look at Section 29 thereof, requirement of information and research, protection against denial of treatment based on religious beliefs. And this is significant, as you notice, embeds medical law and bioethics into HIV legislation. And as I said, this is an entirely new normative, and it's a novel addition. The fifth thematic site for comparison is confidentiality, privacy, and disclosure regime. If you look at Access 1.3, that's the 2002 law, there was no provision on confidentiality of HIV status, disclosure, and privacy safeguards. But under the 2016 edition, we have a detailed confidentiality regime, including prohibition on disclosure without consent, creation of limited public health and judicial exception, and then it prohibits compelled disclosure except as permitted by law. So you can see Section 30. And this is definitely important for modern data protection. If we look at the Data Protection Act, that is a very important area. Again, with respect to socioeconomic rights protection, that is employment, education, insurance. Access 1.3, there was no protection against workplace discrimination or insurance exclusion or education exclusion. But Act 938 explicitly, that is directly provide for such protection. So the right to work and reasonable accommodation, as you saw in Section 32, right to education, Section 33, insurance, pensions, and social security, Section 31. Again, when it comes to sexual and reproductive health, we have a radical innovation. Radical innovation in the sense that the old law, 2002, Access 1.3, was completely silent on marriage, as to if your HIV affected person could do actively be encouraged to marry, could do have a family life. They do have reproductive autonomy. Now, the new law, that is the 2016 legislation at 938, explicitly guarantees the right to marry. right to found a family, sexual and reproductive health right, irrespective of HIV status. And this is very important because this directly confronts cultural and moral stigma associated with HIV and aligns our HIV law with the gender equality and autonomy norms. Another area of comparison is the National HIV and AIDS Fund, structural financing change. So if you look at Access 1.3, it relied on government subvention and donor funding, and there was no dedicated statutory fund. But Act 938 has established what we call the National HIV and AIDS Fund, with defined objects, a dedicated management committee, tax exemption, and also parliamentary oversight. And this is important because it ensures financial sustainability and accountability. And which also with respect to board composition and governance, that is another fertile area for comparison between the old repealed Access 1.3 and the new legislation Act 938. So if you look at Access 1.3, the board of governance of the board of the governing board of the AIDS Commission was quite large and unwieldy. The vice president was the chair, and there were over 30 members, including numerous sectoral bodies. But if you look at the Act 938, it has streamlined and rationalized the board. It's more policy-oriented board. So the president is the chair. The membership is reduced. And we also have a clear committee structure, an explicit legal and ethics committee. So this is important as it ensures a functional governance efficiency. So in your notes, you see just a tabular presentation of these differences. So I will just take any outstanding question before we end. We have 2 minutes and I will end the class.
Yes, my lord, this is Silvanus.
Right.
I have 2 questions. Concerning testing of HIV as a condition for employment, are there no exceptions, especially when it comes to the security agencies, because of the intensity of the training and what they do? Usually, it's one of the things considered, not because they want to exclude somebody, but for the safety of the persons. I want to know, are there no exceptions for such situations? And my second question is, person is known being a sexual tourist who comes to Ghana, and there is evidence that he intentionally goes around to spread HIV. Is that not enough for the government of Ghana, in the name of public health, to restrict that person's access to the country?
Okay, so we start from the second one. If someone, not even only a foreigner, even Ghanaian, if you are known HIV positive and you are deliberately going around infecting people, if it can be proven, that that is criminal, because that is intentional transmission. That is intentional transmission. Now, with respect to the work, if you look at the section 32, if you look at section 32, I have the legislation. I just want to share that with you. Yeah, so section 32 will the right to work. A person shall not discriminate against another person, the partner or close relative, of the other person in the workplace on the sole account of the actual perceived HIV status of that person. 2, an employer shall initiate no. So this applies to those who are already in the work. But if you look at the subsection 4, HIV status of a person, the partner or the close relative of that person, shall not constitute a reason to refuse employment, or B, terminate employment of that person, except where an employer can prove that the requirement of the employment in question is that an employee must be in a particular state of health or medical or clinical condition. The relevant standard in an employment-related issue shall be the fitness for work of an employee. An applicant for employment shall not be tested to ascertain the HIV status of the applicant for the purpose of recruitment, promotion, or any other reason. An employer, in consultation with the employee or the representative of the employee, shall take measures to provide reasonable allowance for an employee with an HIV or AIDS-related illness. Then 8, an employer shall enable an employee with an HIV or AIDS-related illness to benefit from rights that pertain to an employee affected by a long-term illness when the employee is no longer able to discharge the duties for which the employee was engaged on account of poor health. Yeah, so as a general rule, you cannot discriminate, but if you can, as an employer, if you can go to court or the Labor Commission and make the case that having regards to the nature of the work to be done by a particular employee you're employing, the person must have a certain medical status. I mean, an exception could be made, but you also have to make a case for the exception to be given you. So you have the burden. So the burden of proof is on you, the employer, to prove that there is a case for letting you, quote and unquote, discriminate or insist that an employee should not be an HIV person. So you have to discharge that burden of proof before the court or the Labor Commission will allow you. Yes, very well. Mavis, and then Rebecca, and then we are done. It's 8.
Good evening. Please, one minister made a statement in Parliament, and I think was even shared on our platform, that it must be mandatory that every organization checks the status of the person they employ. And when is the proof where the act also prohibits sinful employment? So, in the issue where, based on the rise in cases we have in the country, okay, in a way accepted in Parliament, doesn't mean that they will have to amend the act before it is accepted, or because of the act, this can't happen.
I mean, the politician is not a court, so he just expresses his opinion. It doesn't carry any weight of authority in that respect. So it's an opinion. Mm-hmm. Yeah, Rebecca.
Yes, Doc, I want to find out about the churches. Initially, there was no provision for marriage, but later in 2016 there has been. So the churches, some of the churches, do they know this? Because I think I said an experience some time ago where some churches will have to deny marriage because the partner, one party is HIV positive and the other is negative.
Yeah, now you know the law. As to whether they are aware, you have to do the empirical research to gather the data. But you know the law now.
Fortunately, they are still denying people, and then
so that's why people should take matters up and go to court. Go to court, go to SHRAD, and let us get a judicial pronouncement.
Okay, sir.
Right. Have a good night.
All right. Good night.